Welcome to the first class of test series plus crash course of general studies. The idea behind the crash course is to fill the gaps in your notes as well as in information and not to waste your time. So as far as the current developments in Indian polity is concerned, because most of you have already prepared Indian polity for prelims, I need not to discuss the fundamental issues, but I will be discussing the expected topics. These are the expected topics which are very in news in recent. Plus, at the same time, they are also all-time favorite questions of UPSC. So, we have tried to integrate the foundational and the current aspects of the questions. I have prepared the model answers, but the model answers are beyond the word limit because the basic objective is not just to give the structural answers, because if I'll give a structural answer and sometimes you are looking for explanation, you may have to search the material. So you don't have to search the material, you can shorten it according to your convenience, but the objective is whosoever is reading this answer should get the holistic understanding of the issue asked. So now I will start with the first question. The first question is, some of the recent observations by Supreme Court has put recent observation by Supreme Court has put the spotlight back on the debate of Uniform Civil Code. What aims does the introduction of Uniform Civil Code seeks to achieve? What are the arguments for Uniform Civil Code and against it? Fine. So the question is, the basic knowledge that you should have to answer this question is, what are the recent observation? Which is the recent case? Fine. So case related to the Goa Uniform Civil Code. So you should know about recent observation. And what is the observation of Supreme Court? Supreme Court said that this is the shining example. So if you know, it's good. Has put the spotlight back on the debate. It means there has been debate earlier also. So earlier debate we will trace to the Constituent Assembly, then in a big way in 80s when Shah Banu judgment came. Then we will have to write some important cases, for example Sarla Mudgal case, Shah Banu case, Triple Talaq case. Fine. And then what are the aims? So first of all, whenever we have to write an answer, we have to first in the rough work do one thing. First is recent observation related to Goa, Uniform Civil Code of Goa, and the key word here is the shining example. Fine. And then Supreme Court has put the spotlight back, means where the spotlight was earlier. So first in the Constituent Assembly and then in 1980s onwards, the important cases, for example, at least Shah Banu case, you can remember Ismail Faruqi, Sarla Mudgal case, any relevant cases. Now spotlight back on the debate. Fine. So this is the debate, which is quite old debate, and what aims those who support uniform civil code, what are their arguments? So their arguments, first argument is the national integration argument, that it will result into the minorities gradually getting assimilated into the wider Indian identity. Second argument is the gender justice argument. Third argument is that when there are different systems of law, then it is a troublesome for judiciary, and that delays the process of justice. So for the sake of speedy justice, it will be much better if the laws are refined, reformed, modernized. Fine. And what are the arguments for and against it? So arguments for it is that it is high time that India should go for uniform civil code, because it is one of the constitutional promise. And the argument against it is that the same article which says that India should go for uniform civil code also says that a state shall endeavor to take those or to develop those conditions which create a suitable environment for creation of the uniform civil code. So if you see the current scenario, maybe that environment is yet to emerge. For example, you can give reference to the views of Law Commission. That Law Commission said that though it is a desired goal, but we should go step by step. First, we should try to bring the gender equality within religion and then between the religions. And then you can say that it is not essential that you have to go for one laws, considering the diversity. Recently there is an approach for a multicultural approach for citizenship. Minorities' rights needs to be protected, and as our understanding of equality is becoming deep, we can understand that equality is not just the equal treatment, equality is also the differential treatment. Fine. So this is how we will touch upon the different aspects of the question. So what are the different aspects of the questions? Fine. So for example, how will I prepare the structure of the question? The question is saying the recent judgment of Supreme Court has put the spotlight back. So I will have to mention the recent judgment related to Goa Uniform Civil Code, and Supreme Court says that Goa is a shining example. Then I will have to address this thing. It has put the spotlight back. Means Uniform Civil Code has been a matter of debate. Either you can go to First Law Commission or you can just write from the Constituent Assembly. So even before independence it was debated, in the Constituent Assembly it was debated. Then the prominent persons you can mention about Ambedkar, about Pandit Nehru, about Hansa Mehta, Rajkumari Amrit Kaur, about the members of minority like Poker Sahib. And then again, when the debate again renewed, so debate was renewed in mid 1980s with Shah Bano judgment. Fine. And then the question says, what are the aims it seeks to achieve? Aim it seeks to achieve. Fine. So you can always mention that Uniform Civil Code is mentioned into Article 44, which is a part of the directive principle of state policy. So directive principle of state policy tries to establish a welfare state in the country, and the very idea inherent in the welfare state is the protection of the vulnerable sections of the society. So in this context, we can say that the women among minorities can be considered as one of the most vulnerable sections. So the idea is to upgrade their status, give them a genuine sense of equal participation in a genuine sense and not just in a very, very formal sense. So women among the minorities, and you know that India is a traditional society and Indian Constitution is a revolutionary document, in the sense our Constitution is itself has an objective to bring change in the society, to make India a modern society. So something like this you can discuss. And what are the arguments in favor of it? The arguments in favor, you can write, for example, speedy justice, gender justice, and national integration. And arguments against is basically the Constitution itself says that the suitable conditions should exist. And the next thing is that unity does not mean uniformity, and Indian conception of unity is unity in diversity. So we have a culture of pluralism, we have a culture or we have a multicultural approach towards citizenship, and as diversity is increasing even in the Western countries, even they are thinking of going for a multicultural approach to citizenship. And it should not happen that the attempt to the Uniform Civil Code appears as if it is a tyranny of majority. So doing right thing is important, but doing right thing in a right manner is also important. So Law Commission rightly said that Uniform Civil Code remains a goal, but at present maybe the conditions are not convenient enough, and in the end we should continuously be trying to develop the trust with the minorities. So until and unless that trust and confidence develop, maybe it can have some counterproductive results. So you should also show how you think about it. And now this is something which is the essential part of the question. After that, if you want, you can go for embellishment of the question. You can go for ornamentation of the question, because it is related to justice. It is related to idea of justice, it is related to good governance, it is related to laws. So if you have some knowledge of Indian culture, you can bring certain ideas to embellish your answer. Otherwise, these points are going to be the major points which have to be there. So normally what will happen in UPSC, examiners will be given the model answer. Model answer is not that how the flow should be, but what are the essential ingredients of this particular answer. So this is how your answer will be evaluated. So I will pick up the copy of one of the student, and we will see whether that student comes near to our expectation or not, and how should we evaluate the copy. Fine. Some of the recent observations by the Supreme Court has put the spotlight back. Now let us see how this person has started. So according to Article 44 of Indian Constitution, the state shall endeavour for a uniform civil code for Indian citizens. Since Article 44 is under the directive principles, hence non-justiciable, there has been no positive development in this regard. Now, I will not consider it as a good introduction, though this person has started fine, but he has started giving judgment. He is getting judgmental. Fine. So first thing is, whenever you start, don't start from the margin, because your presentation also matters and there is a word limit. So you can avoid this word according to, you can directly go that Article 84 of the Indian Constitution suggests that, or Indian Constitution I will not waste these words. Article 44 of the Indian Constitution directs that the state shall endeavour to establish or to bring a uniform civil code. Okay, it is nowhere mentions for Indian citizens specifically, so don't link it. Since Article 44 is under directive principles and hence non-justiciable, there has been no positive development in this regard. So this is not required, since Article 44 is under directive principle. Hence it means as if none of the directive principles have ever been made. Government didn't make any attempt to implement any directive principle, and it appears as if you are very angry and you are very judgmental, you are very emotional person. So when an answer is checked, your personality is also checked, not just your information. Hence non-justiciable, and there has been no positive. How can you say there has been no positive development in this regard? So there has been a development. There is a Muslim woman protection of rights in Divorce Act. There is a triple talaq related act. So how can you say there is no movement? And there is a movement because state has made laws for Hindus, there is a laws for Sikhs. Fine. So don't be so strong and so judgmental in your answers. Next, so I will Anyway, let us see how we will evaluate this. A uniform civil code aims to replace the personal laws of each religious community with a common code. Instead of various laws for each religious community, a single set of guidelines will rule over their personal matters. The thing is, you are unnecessarily, you have already written this, now you are unnecessarily repeating it. Either write this or this. So now you have told the purpose of uniform civil code. Fine. And you are not going in the flow of the question because you have not addressed the spotlight. The pros of introducing uniform civil code are: in accordance with Article 15 of the Constitution, which strives for no discrimination on the basis of religion, ending practices of religious traditions which are in contrast to fundamental rights. So instead of this, strives no discrimination on the basis of religion. So it will strengthen the idea of gender justice, and it will give meaning to the right to equality, and it will end the practices of the religious tradition which are in contrast to fundamental rights. So don't be so harsh. It's a good point. It will help in weeding out those customs and traditions which are not in sync with the values of modern society. Something like this. It's a good point. In accordance with the vision of our founding fathers. So vision of the founding fathers. This is not a very strong ground which you have mentioned. And for all of the students, I want to point out that generally we take this meaning: a uniform civil code aims to replace the personal laws of each religious community with a common code. So this is the general meaning. The general meaning of uniform civil code is all communities should be governed by the single set of laws. But in practice, it means that a state should have power to make law. For example, in India, a state has made the laws for Hindus. In India, a state has made laws for the Sikhs. So it's not necessary one law has to be made for all, but the practical meaning is the state getting power to make law on the personal matters. So in every modern state, in medieval time, this uniform civil code is an idea of medieval time in Europe where church was dominating. So when the modern age started, a state became, the principle of sovereignty of a state came into existence, and a state got power to make laws. And because the state has to make law according to the constitution, all laws appear same. Okay. So next, the pros of introducing uniform civil code. This is again not a right sentence. You can say the arguments in favor. This we have already seen. Promotion of national integration and a step toward nation building. As per Indian concept of secularism, a state can make laws related to religion if it aims to end the inhuman practice. Fine. So this is a sort of a repetition of this point, ending practices of religious tradition, and this could have been combined. In that regard, positive feature. The arguments against, see, either you write pros and cons or you write favor or against. So there should be symmetry and harmony in the words that you choose. The arguments against are fear of imposition of majoritarian laws on minority, valid argument, communities, be it tribes or Muslims, and hence it will impact diversity. Uniform Civil Code is in conflict with Article 25 and 29 of Indian Constitution, and then full stop. There will be no need to balance the two. There will be need to balance the two. But it is in conflict balance. How this balance is being disturbed? How to bring this balance? How will you write? How will you substantiate? Different communities have different political laws. It might lead to politicization and hence communalization of the whole issue, impacting the process. So you can say that, as Law Commission has rightly mentioned, that our country still is not prepared for, until unless that basic trust building is not there, it can be, any attempt can get hijacked by the communal forces and they can project it in some other manner. Personal laws are mentioned in the concurrent list. If exclusive jurisdiction needs to be given to Parliament and make it truly informed, it can be transferred to the union list. So either you are telling to the cons or you are telling how we can bring uniform civil code. Means you are not organized in your thinking. Thus, uniform civil code will have to be an evolutionary process. It will be needed to be developed by consensus, where each community view is respected, debated and evaluated. That is fine. As per Law Commission recent report, it is neither feasible nor desirable. Fine. But you have not touched the spotlight back. So I think if I have to test your current awareness, that is missing. If I have to test your personality, I feel that you are emotional and the emotional outburst about the entire issue has happened here. Fine. And though your conclusion is fine, but the choice of words and the sentences could have been better. Fine. So I am not giving marks as such, but I am telling you what, like as such, how is your answer. Fine. So for the students, just you can just note it down few things. So I will show first the content that I have developed. So whenever reform for the laws are concerned and you do not get any specific quote, you can always start with Sarve Bhavantu Sukhina, Sarve Santu Niramaya. Fine. Means the objective of the Uniform Civil Code, the objective of the reforms is well-being of the all. This is embellishment. May the well-being of all be protected. Fine. Answer will be there even without it, but it can fetch you some additional marks. And in the answer which I had discussed, the problem in the answer was that it was not having, you have completely missed the spotlight back on the debate. Fine. So the debate on Uniform Civil Code is more than 180 years old, when the Second Law Commission in 1835 considered the matter and consciously decided to keep the personal laws separate. Then even it was a hotly debated issue in the Constituent Assembly. Women leaders like Rajkumari, Amrit Kaur and Hansa Mehta wanted the introduction. However, Sardar Patel, Malviya were against it. Minority leaders like Muhammad Ismail and Pokar Sahab were against. Ambedkar held that it should be introduced but it should not be imposed. Pandit Nehru somehow, despite being modernist, had sidestepped the issue. Fine. So in recent time, the debate is renewed with the judgment of Shah Bano case in 1985. The Supreme Court bench observed. Now I have written the exact words, but for you, you can write in general also. There is no need that you write word by word. There is no evidence of any official activity for framing a common civil code for the country. A common civil code will help the cause of national integration by removing the disparate loyalties to law which have conflicting ideologies. Fine. So this is saying that there is no official activity, and the case itself said that common civil code will strengthen the cause of national integration. So when I am writing arguments in favor, you can also mention this: removing disparate loyalties. Next, at least in polity questions, you should write some prominent judgments. In Sarla Mudgal case, court reiterated the need for parliament to frame a uniform civil code which would help the cause of national integration by removing ideological contradictions. Now very recently, Jose Paulo Coutinho versus Maria Pereira case, while delivering the judgment legitimizing the Portuguese civil code, Supreme Court held that Goa is a shining example with a uniform civil code and hoped and expected that the founding fathers had expected. A uniform civil code is commonly understood as a single law applicable to all citizens in their personal matters such as marriage, divorce, custody, adoption, and inheritance. Fine. Here you just add one point, right? However, in practical sense, uniform civil code implies state making laws based on modern values. Fine. Then right, it is not necessarily a single code. The deeper meaning is reforming the personal laws. Fine. However, they appear similar. Because a state has to make the laws in accordance to the constitution. So basically, they get in aligned with the constitution. Okay. And what is the probability of this question coming? Very high probability, because it is one of the priorities of the present government. And the second thing is, it is also frequently asked question. Next, what is the aim? In general, following arguments are advanced in favor of uniform civil code. First is equality. So personal laws are widely divergent. Non-patriarchal laws, gender justice, simplification of law to address this delay, strengthen the secular nature of the Indian society. You can simply write these points. It will strengthen the national integration, and that point can additionally be added, which this student has given, which was a good point, that it will help in reforming or it is like rejecting of the customs and traditions which appear contradictory to the modern way of life. Maybe once these customs and traditions were fine, but not at present. This is a good point. In fact, Sir Syed Ahmad Khan himself has brought one magazine, Tehzeeb ul Akhlaq, and Sir Syed Ahmad Khan held that those customs and traditions which have outlived its importance, they should go and they should be reformed. Fine. Now, arguments against Uniform Civil Code: homogenizing effect, implementation challenges. There are bound to be strong protests against any such move. There is no single common personal law for any religious community. Even in Jammu and Kashmir, Hindu laws come near to the differ from central enactment. The Shariat Act governed Muslims of Kashmir, which in many ways are variants with the Muslim personal law in rest of the country. Then in Northeast there are more than 200 tribes, and it is, according to some point of view, it is considered as undemocratic. State action is against the quintessence of democracy, as multicultural approach to citizenship is now an integral feature of democracy. So, way forward: Law Commission. The best way forward is to reform the personal laws, ensure that they are not discriminatory across genders, do not violate the fundamental rights. The legislature should first consider guarantee equality within community rather than between community. This is a very crucial point. Fine. And then you write your own perspective. Thus, our reformative approach should be adopted, as hasty action will allow the vested sections to hijack the issue. In the long term, UCC will certainly enable the men and women of this country to be more aware of their rights in accordance to the spirit of Universal Declaration of Human Rights. Okay, so these are points, but क्या करना है out of all this entire notes, इसमें कुछ चीज़ों को हाईलाइट कर लो और उसको डेली रिवाइज करते रहो. जैसे ये मान लो कोट है, ये यहाँ नहीं तो this you can use somewhere else. You can even get an essay on Uniform Civil Code. ठीक है. Second, just keep this in mind. Second Law Commission 1835. Name of the persons in the debate: Amrit Kaur, Hansa Mehta, Ismail Pokar Sahib, Ambedkar and Pandit Nehru. Then remember the important cases, at least two cases: Shah Bano case and the year, then Sarla Mudgal case and the year, and this Coutinho versus Maria case. And then just key points, it will bring equality, gender justice, simplification, secular nature, national integration and reform of customs and traditions. To make a keynote out of this answer. Fine. Then homogenizing effect, implementation challenges, undemocratic and way forward. जैसे you can do it. Law Commission 2018. Keyword: first try to bring equality between the communities. There is also one suggestion that like company law board, there can be personal law board to advise the government. If you want, you can also write that. It is suggested that like company law board, there can be a personal law board. Fine. Now let us take the second question. So now I will take the answer sheet of another student, fine, and we will evaluate how that student has handled question number 2. The question number 2 is, discuss the constitutional position of the state of Jammu and Kashmir since the enforcement of the constitution application to Jammu and Kashmir Order 2019. Let me see the exact question. Since the enforcement of the constitution order. Fine. So discuss the constitutional position of the state of Jammu and Kashmir since the enforcement of the constitution applicable to Jammu and Kashmir Order 2019. So what are the expectations? The expectations are, first of all, we should tell about the unique position enjoyed by Jammu and Kashmir, and we can discuss the unique position enjoyed by Jammu and Kashmir in context of the special history of Jammu and Kashmir and in the broad framework of asymmetrical Federation of India. Fine. So basically, India is a land of enormous diversity. At the same time, India is an example of unity in diversity. Normally, in the countries which are large and heterogeneous, federalism is adopted as a form of constitution. Indian constitution is an example of asymmetrical federalism. Now, asymmetrical federalism is the best way to address the diversity in accordance to the norms of democracy and multicultural approach to citizenship. Asymmetrical Federation of India has allowed Jammu and Kashmir a special status, though in the constitution it is mentioned as the temporary status. This status was because of the special conditions that were existing at the time of the partition and the manner in which the state was integrated. Maharaja Hari Singh was not, or Maharaja Hari Singh wanted Jammu and Kashmir to remain free, but after Pakistan's aggression, he has signed the Instrument of Accession. In order to legitimize the entire process, our Prime Minister has promised that the final integration of the state of Jammu and Kashmir will be based on the will of the people of Kashmir, and hence in Jammu and Kashmir's constitutional status with the Union of India was to be governed by Article 370, which is seen as a temporary status, which means that in future this status has to be changed and some permanent feature has to be incorporated. And Article 370 gives the autonomy to Jammu and Kashmir to ensure or with respect to dealing with the local issues. So it was a flexible arrangement where all provisions of the constitution and all union laws would not have been transferred automatically. Either they have to be done with the consultation or the concurrence of the state government. So since Article 370, which was supposed to be the transitional or a temporary provision, has become almost a permanent provision even after the 70 years. Now, from the very beginning, Article 370 has been a matter of debate, whereas one segment of Indian society, Indian political section, felt that or described it as a tunnel to enter or to pierce the wall of Jammu and Kashmir. The other section of Indian public opinion considered that it will prohibit the complete integration of the Jammu and Kashmir, and it strengthens or it provides a legal basis to the separatist trend in a geopolitically sensitive country, sensitive state of Jammu and Kashmir. Now, Jammu and Kashmir is a multi-layered and a highly complex problem because it is not dealing with the state, is not just a center and state issues. Rather, it involves many countries, not just Pakistan, it involves China, it involves US. So, managing Jammu and Kashmir is not that a easy task. From 1980s, because of the US policies in Afghanistan and the rise of radical or fundamentalism, Islamic fundamentalism, we also see the strengthening of the separatist trends in the region. Gradually, Chinese ambitions are also increasing, and Pakistan, as a proxy state of China, is working on Chinese direction to fuel the insurgency in Jammu and Kashmir. So since mid-80s till present, the government of India has been maintaining the autonomy status of Article 370 and has been carrying a war of attrition, or has been defending or managing the war of attrition. However, 70 years is a very long period in the history of any republic, and as it has been observed, there is some sort of tiredness now with the existing policy. So the present dispensation has felt that you need to change the rules of engagement, and this has to be changed further more in the context of the developments which are taking place in India's neighborhood. For example, China's assertion of, or China's assertiveness, and China's plan to build CPEC corridor, which goes through the Pakistan occupied Kashmir against or without respecting Indian sentiments. The withdrawal of the US forces from Afghanistan will also put a pressure or may increase the insurgency. So India has to give a clear message to the world that we are very firm in our resolve, and we will not even shy from taking the hard decisions as far as protecting India's territorial sovereignty and integrity is concerned. So as a result, status quo has to be changed, and government has come up with a new decision. Now what will be the long-term consequences of this is yet to be seen, but yes, the status quo was also not a desirable action when China's assertiveness is growing and India looks itself as a emerging power, or the entire world is towards looking at India as a net security provider in the region. So government had planned to change the rules of engagement, and hence on 5th and 6th August 2019 the two resolutions have been passed, which has resulted into an alteration in the status of Jammu and Kashmir. And by these two resolutions, all the provisions of the constitution have been extended to Jammu and Kashmir, and when all the provisions of the constitution have been extended, automatically all parliamentary laws have been extended. Fine. The government has justified this particular decision that it will check the separatist trend, it will promote the development of this particular region, it will address the problems of the youth, because if you want to tackle militancy, you have to address the alienation of the youth. Now Jammu and Kashmir, because of Article 35A and because of certain restrictions, the outsiders could not have gone and settled there. Foreign universities or Indian universities, private sector cannot set up higher universities or cannot set up that enterprise. And it is also believed that certain laws like right to education or domestic violence laws act, which were not available to Jammu and the women of Jammu and Kashmir, will also be extended. So these are certain justifications given by the government, though there are many people who believe that the step will further increase the insurgency and the separatist trends in the region, and government's decision has been challenged in the number of petitions in the Supreme Court. So we have to yet see what will be the short-term and the long-term consequences, but we can definitely say that a status quo cannot be considered as a policy, and India's Kashmir policy needed the change, and hopefully this change brings more positive integration of the state along with securing the well-being of the people of Jammu and Kashmir. So this is how you can handle this particular question. Fine. Now I tried to explain the circumstances in a way more holistically. Let us see what are the points which you should have written in your answer. So first we will discuss the unique position enjoyed by Jammu and Kashmir in India's asymmetrical federation, which gives enough flexibility, and then we will discuss that the factors that led to the resolution or constitutional orders 272 and 273, after which what changes have happened in the state of Jammu and Kashmir. So this has been the main question, discuss the constitutional position. So in a way, now Jammu and Kashmir's constitutional position is almost similar to all other states. Though Indian constitution didn't have the special provisions only for Jammu and Kashmir, there have been special provisions even for Nagaland, even for Manipur, even for Sikkim. But Jammu and Kashmir's position is more or less like the other units. And at present, this is for the first time that a state has been converted into a union territory. So right now Jammu and Kashmir is a union territory. Now this answer does not end here, though the question is not asking, but from your side you will have to give a rationale, you will also have to justify it to end this particular answer. So once there was a question on 370, so there can be a question on article 370, and let us see whether this student satisfies the need of the or expectations of the answer. So the purpose of Constitution Application Order is to achieve the complete national integration. Why national integration? It is enough if you write integration. Earlier position under Article 35A and 370, JK enjoyed a special relationship with Union of India. The control of Union of India over JK only extended to the matters of communication, security and external affairs. It was meant to be a temporary provision. So this part is actually factually wrong. Fine. So this is factually wrong. An earlier position, it would have been better if you have just mentioned about Article 370, because it's not that the control of Union of India is only on this matter. There are two types of matter. The provisions of the Constitution can be extended by consultation, by concurrence, though it was not needed, but here you have committed an error. Please don't commit the factual errors. And then you can say that Article 35A, which is the result of Article 370, has also been a bone of contention because it gives certain privileges or it establishes the ideal of dual citizenship in case of Jammu and Kashmir. It was meant to be a temporary provision. With the 2019 order, the provision was removed and state of JK was reorganized. The state was split into two UTs. The High Court of JK will serve the judicial interest of both the union territories. The question actually doesn't ask internal status, but fine, if you've written the separate flag has been abolished, the autonomy has been greatly reduced. This is the good point. It would now be subjected to the directions on all such matters as any other union territory. Fine. The constitutional downgrading of JK from a state to UT is an unprecedented. That's good answer. The center hopes with its increased power it will be able to curb the insurgency. Fine, okay. Central government would be well advised to remember that with great power comes great responsibility. So I think this statement is unnecessary. Who is a great power, great responsibility, what you mean to say, and how you are linking this statement with this particular answer. Fine. So it is a abrupt ending. Fine. Some part is fine, but the question is ending in an abrupt manner and I don't understand what is the purpose of this particular conclusion. Fine. So now let us see. See, because the Kashmir is going to be an expected issue, I have added this quote from Kalhan that Kashmir can be won by the power of spirit but not by the power of sword. So Jammu and Kashmir enjoyed special status under Article 370. As a result, JK had its own constitution and all laws passed by Indian Parliament were not automatically applicable to the state of Jammu and Kashmir. On 5th 6th August, this is a factual part, as a result it has been reorganized. Now all the constitutional provisions and laws of Union Parliament will be applicable. JK will have no separate flag. IPC will replace the Ranbir Penal Code. The Parliament has also passed JK Reorganization Act. Now some points of that answer, that a common high court will be there, you can add. Government has given the following rationale behind changing the constitutional status. So even if it is not asked, you have to write 4-5 lines, because the question can be asked in a different manner also. So I have added certain additional points here. So it will result into complete political integration. These points I have taken from the affidavit submitted by by the Government of India in Supreme Court against the petitions. It will accelerate the economic development, it will boost higher education, it will result into empowerment of women, protection of children, and this point I have added on my own. With increasing assertiveness of China and developing Pakistan axis, it was essential to assert India's claim. The change in the constitutional status was bound to give controversies, not just within the country but even outside. However, with the exception of China and Pakistan, the initiative has got support from international community, including the Muslim countries of West Asia. Petitions are pending. It is to be noted, then the last line you should tell how you look at the entire issue. It is to be noted that Kashmir has been suffering since the last 3 decades. The constitutional concessions have not facilitated integration, hence the rules of engagement had to be changed. However, how do you look at the change? Change is a work in progress. While abrogation of Article 370 has been a necessary condition, it is by no means a sufficient condition. Okay, so you should give how you look, and since it's a probable question, you can remember the introduction and the conclusions. Fine. Now let us do the third question. So the third question is, for that third question I have taken the copy of some other student. Fine, and let us see how this person has written. So what changes have been introduced by Citizenship Amendment Act in Indian citizenship laws? What controversies are attached to the amendment, and can CAA be challenged under Article 131? So this is again a current issue, and this issue has raised eyebrows not only within the country but also even outside. There have been the protest. One of the longest protests has been the Shaheen Bagh protest. So definitely there is a possibility, and if you see most of the articles are against the decision, and they believe that Citizenship Amendment Act violates Article 14 and secular dimension of the Constitution, and this has also been challenged in the Supreme Court. So again, it is a matter which is sub judice, but we also need to know what are the government's point of view. So again, in the government's affidavit there are certain arguments that have been written. Now, the Citizenship Amendment Act, because it is so controversial, the students have a problem like how they will take a stand on that. It's better you take the stand according to from the perspective of the government, because government perspective is not altogether wrong. Fine. So let me briefly explain the issue. What challenges have been introduced by the Citizenship Amendment Act? Fine. So basically, Citizenship Amendment Act ends the status of illegal immigrants for the members of 6 religious communities: Hindus, Sikhs, Buddhists, Jains, Parsis, and Christians living in Afghanistan, Pakistan, and Bangladesh. Fine. And it reduces the time period of within which they will be getting the citizenship. So it is the route for citizenship, and they will not be treated as illegal immigrants. So if they will be treated as illegal immigrant as per 2003 law is one who does not possess the valid document. Now if they are treated as illegal immigrant, they will be subjected to penalties, they can be deported, but it protects them. And considering the sensitivity of the northeast, the northeastern states have been exempted. Fine. So first is the factual part that you should know. Now there is a controversy that this is against right to equality, and those who says that this is against right to equality and secularism, because in India equality before law under Article 14 of the Constitution is given to or is secured even to the non-citizens. Besides this, Article 14 is the basic structure of the Constitution which cannot be violated. So it is held that this particular law is discriminatory against the Muslims, because Muslims, like in Pakistan, the Shias and Ahmadiyas, they have also been subjected to religious persecution. Then it is also putting a question mark on why it does not involve the Tamilians from Sri Lanka or Rohingya Muslims from Myanmar. Fine. So these are certain issues, and it is held that the agenda of the government is a sort of like build India as a Hindu nation like Israel. So Israel's citizenship laws allows the Jews from anywhere in the world to get the citizenship. So it is simply the Hindus from this part of the country or from anywhere right now from the neighborhood. So India as a land of Hindus, whereas India is a secular country. So these are certain argumentations, and there is a problem in defending this particular law. As you have seen the Shaheen Bagh protest, you have also seen the civil society support for Shaheen Bagh protest in India, public intellectuals, even there have been protests outside the country sometimes. At times it has been provoked by Pakistan also. So how you should look at the entire issue? So our challenge is that we have to defend the position of the government. So the best way is look at the document itself by the government. So government, or if you see the statement of the objective attached to the bill, this itself mentions that the idea is to complete the unfinished agenda of the partition. So now I will give you a quick glance of the complications of the Indian citizenship laws and how you can defend this particular argument. The points I have basically taken from the affidavit which has been filed by the government. Okay, and I will also discuss it in the format of the questions which I have asked and how I should have addressed. So the question is, what challenges have been introduced by the Citizenship Amendment Act, then the controversies, and can it be challenged under Article 131? So the question is, what are the changes introduced in Citizenship Amendment Act 2019? What are the controversies attached to it, and can it be challenged under Article 131? Fine. So first of all, how will I open up this question? I will first explain what is citizenship, or what is meant to be a citizen of a country. Fine. So citizenship is basically a legal status between the person and to the state of which he is a citizen. So it's a two-way street where person gets certain special rights which are not available to the citizens, as well as the person has certain obligations towards the state. So this is the general meaning of citizenship. Okay, and if you see that in international law, citizenship is called as nationality. And if you see that one of the reasons for the Second World War was the atrocities on the minorities, the atrocities on the religious minorities, that is Jews, by the government, not just in Italy but many European countries. And after that, the Universal Declaration of Human Rights also recognized that every person has. So the third question is, for that third question I have taken the copy of some other student. Fine, and let us see how this person has written. So what changes have been introduced by Citizenship Amendment Act in Indian citizenship laws? What controversies are attached to the amendment, and can CAA be challenged under Article 131? So this is again a current issue, and this issue has raised eyebrows not only within the country but also even outside. There have been the protests one of the longest protests has been the Shaheen Bagh protest. So definitely there is a possibility. And if you see most of the articles are against the decision, and they believe that Citizenship Amendment Act violates Article 14 and secular dimension of the Constitution, and this has also been challenged in the Supreme Court. So again, it is a matter which is sub judice, but we also need to know what are the government's point of view. So again, in the government's affidavit, there are certain arguments that have been written. Now, the Citizenship Amendment Act, because it is so controversial, the students have a problem like how they will take a stand on that. It's better you take the stand according to from the perspective of the government, because government perspective is not altogether wrong. Fine. So let me briefly explain the issue. What challenges have been introduced by the Citizenship Amendment Act? Fine. So basically, Citizenship Amendment Act ends the status of illegal immigrants for the members of 6 religious communities: Hindus, Sikhs, Buddhists, Jains, Parsis, and Christians living in Afghanistan, Pakistan, and Bangladesh. Fine. And it reduces the time period of within which they will be getting the citizenship. So it is the route for citizenship, and they will not be treated as illegal immigrants. So if they will be treated as illegal immigrant as per 2003 law is one who does not possess the valid document. Now if they are treated as illegal immigrant, they will be subjected to penalties, they can be deported, but it protects them. And considering the sensitivity of the northeast, the northeastern states have been exempted. Fine. So first is the factual part that you should know. Now there is a controversy that this is against right to equality, and those who says that this is against right to equality and secularism, because in India equality before law under Article 14 of the Constitution is given to or is secured even to the non-citizens. Besides this, Article 14 is the basic structure of the Constitution which cannot be violated. So it is held that this particular law is discriminatory against the Muslims, because Muslims, like in Pakistan, the Shias and Ahmadiyas, they have also been subjected to religious persecution. Then it is also putting a question mark on why it does not involve the Tamilians from Sri Lanka or Rohingya Muslims from Myanmar. Fine. So these are certain issues, and it is held that the agenda of the government is a sort of like build India as a Hindu nation like Israel. So Israel's citizenship laws allows the Jews from anywhere in the world to get the citizenship. So it is simply the Hindus from this part of the country or from anywhere right now from the neighborhood. So India as a land of Hindus, whereas India is a secular country. So these are certain argumentations, and there is a problem in defending this particular law, As you have seen the Shaheen Bagh protest, you have also seen the civil society support for Shaheen Bagh protest in India, public intellectuals, even there have been protests outside the country sometimes. At times it has been provoked by Pakistan also. So how you should look at the entire issue? So our challenge is that we have to defend the position of the government. So the best way is look at the document itself by the government. So government, or if you see the statement of the objective attached to the bill, this itself mentions that the idea is to complete the unfinished agenda of the partition. So now I will give you a quick glance of the complications of the Indian citizenship laws and how you can defend this particular argument. The points I have basically taken from the affidavit which has been filed by the government. Okay, and I will also discuss it in the format of the questions which I have asked and how I should have addressed. So the question is, what challenges have been introduced by the Citizenship Amendment Act, then the controversies, and can it be challenged under Article 131? So the question is, what are the changes introduced in Citizenship Amendment Act 2019? What are the controversies attached to it, and can it be challenged under Article 131? Fine. So first of all, how will I open up this question? I will first explain what is citizenship, or what is meant to be a citizen of a country. Fine. So citizenship is basically a legal status between the person and to the state of which he is a citizen. So it's a two-way street where person gets certain special rights which are not available to the citizens, as well as the person has certain obligations towards the state. So this is the general meaning of citizenship. Okay, and if you see that in international law, citizenship is called as nationality. And if you see that one of the reasons for the Second World War was the atrocities on the minorities, the atrocities on the religious minorities, that is Jews, by the government, not just in Italy but many European countries. And after that, the Universal Declaration of Human Rights also recognized that every person has. Fine. So Universal Declaration of Human Rights also says that every person has the right to nationality. Right? So actually Article 15 of the Universal Declaration of Human Rights mention about right to nationality. Okay, so if you see this particular law does not deprive anybody the right of citizenship. Rather, looking at the horrors of the xenophobia against the Jews and then the consequences which has resulted into the Second World War, it is in a way showing India's commitment to the Universal Declaration of Human Rights, especially for those who have been the persecuted minorities on the basis of religion. Fine. So it is actually furthering the principles of Universal Declaration of Human Rights. Fine. Article 15 says right to nationality. To despite India having its own such a huge population, we are accommodating the people who have suffered because of the religious persecution. Fine. Now, the second thing is, whenever we have to talk about the citizenship, citizenship has to be seen as the citizenship laws in India. They have to be seen as the work in progress. And this is how our constitution also looks at the citizenship laws. Fine. So citizenship laws are given in part 2 of Indian Constitution from Article 5 to Article 11. Fine. And Constitution does not make the elaborate provision on the citizenship. Rather, Constitution gives the comprehensive powers to the Parliament to come up with the citizenship laws from time to time in accordance to the need and the requirement. Fine. So if you look into Article 11, it gives power to Parliament. And these powers are very comprehensive powers actually. If you read this article, the article says, notwithstanding anything or any provision of this part 3, even whatever constitutional provisions Constituent Assembly has mentioned 5, 6, 7, 8, it is written as notwithstanding that. Means Parliament has a comprehensive powers as far as the citizenship laws are concerned. Fine. Now, the second thing is, Constitution makes very minimal provisions. So if you see from Constitution from Article 5 till Article 10, in the constitutional provisions only deal with the citizenship of status of the persons born in India at that point of time, the migrants who have gone to Pakistan, and who have come back to Pakistan, as well as the persons of Indian origin who were living abroad in the countries other than Pakistan. The rest of the situation has to be determined by the parliament, and consequently parliament has passed Citizenship Act 1955, and which has been amended from time to time. Now for mains, you need not to write in this year this amendment happened, in this year this amendment has happened. You have to just mention about the essence of these laws. Fine. So what has been the essence? That considering the large scale illegal immigration in the country from the neighboring countries, we have been going for making the laws more and more strict. Fine. And unlike US, if you are born in that country, you get a citizenship. India has moved towards not just citizenship by birth, but also citizenship by descent. So we have not just anybody born in India is not citizen until unless his parents are also not Indian citizens. So earlier we had only this principle, just solely, but now we also have this principle, and this is together, just sanguinis. Fine. And another direction was that we are making the citizenship laws more gender neutral. So earlier the father has to be Indian citizen, but now even the mother, either of the parents. Now, considering the unrest in Northeast and especially in Assam, which even Supreme Court has acknowledged as an aggression on the country, in 2003 an amendment was added where it was held that a person will get a citizenship if he is born in the country and one of the parent, either both the parents are Indian or at least a parent should not be illegal immigrant in the country. Fine. Now, why this Citizenship Amendment Act? Why 2019 Citizenship Amendment Act? Because we have seen the events where the minorities have been persecuted. Persecution of minorities, and these minorities, Hindus, Buddhists, Jains, Sikhs, Parsis, and the Christians, they have taken shelter in India, and as the citizenship takes time and the conditions in which they have to leave their country, and the class of these persons from primarily the economically weaker section, at times they do not have the necessary valid document. So as a human right gesture, we are making the access to Indian citizenship so that they can live with dignity, and when government has introduced the citizenship, these people have thanked the government of India also. Now, the question is, why we have included Afghanistan? So basically, you cannot separate the Indian citizenship laws with the history of this subcontinent. Fine. So before the creation of Pakistan, Indian borders were touching Afghanistan, and the partition between Afghanistan and Pakistan, which is known as a Durand line. Fine. This is a colonial boundary and at times contested in the Afghanistan itself and the persons of Indian origin, because it was a borderless world. Indians used to go there for business, they used to settle there. So Pakistan's area, now these areas are in Afghanistan. There are news of the persecution of the people of religious minorities. Now the question is, Shias and Ahmadiyas, why we are not giving this route? So Shias and Ahmadiyas, they can seek citizenship under the regular process of registration or normalization, and Shias and Ahmadiyas, they are not the religious minorities. Though now the constitution, now the Pakistani laws very lately recognize Ahmadiyas as the minority, but they are not religious minorities, they are sectarian minorities. If you ask any Ahmadiyya that are you a Muslim, will they say I am not a Muslim? So the religion is which religion? The Islam religion. Fine. And Shias are also Muslims. So it is not a religious minority. Fine. So long they are the sects of Islam. So it's a sectarian minorities. So this law is for the religious minorities in the countries and not for the sectarian minorities. And if you look at Ahmadiyas, or they have been quite at the forefront of the Pakistan movement also. Anyway, that is not the case, but this particular law is for the persecuted religious minorities, but they are the sectarian minorities. Pakistan is a land for the Muslims of the subcontinent, and so far Ahmadiyas and Shias, they consider themselves as Muslims. They will not qualify for this, though they have not been deprived. They can get still the membership, they can still get the citizenship of the country by the route of registration as well as naturalization. Now, the second thing is, why not Rohingyas from Myanmar? The thing is, Myanmar was a separate country from the very beginning. Though Britishers administered India and Myanmar together, but that doesn't mean Myanmar was part of India. Fine. And in 1935, it was given a complete separate status. Fine. And the present Constitution Amendment Act is like completing the unfinished task of partition. So the partition was done in haste, and at the time of partition there was an agreement between Pandit Nehru and Liaquat Ali Khan of Pakistan, and they said that both of us will, like India will, there will be minorities left in India, there will be minorities left in Pakistan. Even Qaid-e-Azam of Pakistan had promised that minorities need not to fear in Pakistan. The Pakistan of today is also not near to the idea of Pakistan of Jinnah. So minorities have been persecuted, the percentage of their population has declined considerably, and there have been news reported in international media which cannot be denied. So it is like Pakistan or Bangladesh not fulfilling their promise at the time of partition. Fine. So since this citizenship law comes under this context, we cannot equate their situation with the Rohingyas. Fine. Neither we can equate with the Tamils of Sri Lanka. Sri Lanka was never a part of India. Fine, it was a separate country. So this is meant for, like, we trusted Pakistan that once the state based on religion is made, Hindu minorities, Buddha minorities, Sikh minorities will be left behind. We trusted the promise of Pakistan that it will treat its minorities well, but this didn't happen. So the case of Myanmar, the case of Rohingyas is different. Here, the objective of the Citizenship Amendment Act is limited to the undoing of historical wrongs. Okay, now the next is same argument will apply in case of Tamils in Sri Lanka. So Sri Lanka was not partitioned and was not a part of our country. It is a separate issue. We have already accommodated as a part of Indira Gandhi and Sri Mavo agreement. There are different citizenship agreements. We have accommodated the large number of Tamilians as a part of Indian citizenship, and according to the report presented by the High Commission, Indian High Commission in Sri Lanka, there are no more applicants for the Indian citizenship from Sri Lanka. Fine. So this is how you can defend the Indian Citizenship Amendment laws. Fine. So I hope you have understood the broad contours of this citizenship controversy. So now let us see how the student has dealt with what changes have been introduced in the Citizenship Amendment Act, what controversies are attached to. So Citizenship Amendment Act has introduced 3 changes in Indian citizenship laws. The persecuted minorities in Hindus, Sikhs, Jains, Buddhists, Parsis from Pakistan, Afghanistan and Bangladesh who came to India will not be treated as illegal migrant. Area under 5th and 6th schedule is debarred. So fine, from the perspective of fact, citizenship through naturalization has been reduced from 7 years, reduced to 7 years from previously 11 years. Is it not fine? The benefits provided to OCI, but that is not a very important issue. Now controversies attached to it. It is country specific. Persecuted people from Myanmar, Sri Lanka are not dealt. And then another argument of the government is that government constitution gives complete power to the parliament, and Supreme Court has to assume the constitutionality of the law. It is a country specific. It does not deal with the minorities within Muslims, Ahmadiyas in Pakistan and Rohingyas in Myanmar are facing ethnic cleansing. The Amendment Act is silent. The issue related to OCI cardholders are also vague. The Act has defined the violation of which law. Citizenship Amendment Act has been seen in connection with the proposed National Register of Citizens, fine, okay, which has brought Muslims in India on the road to protest against it. Some states like Kerala has challenged the act under Article 131. So, and basically Kerala challenging this act, Article 131 can be used only when the legal right of the state is questioned. The legal right means, suppose it is a subject of the state list and union has made a law. This is not a matter of the violation of the legal right. It is a matter of the political dispute. For that, the better platforms are like interstate council rather than 131. But the contradictory judgments of Supreme Court create a problem, because there is one judgment where Supreme Court held that only legal disputes will be dealt, another judgment where it has said that even certain other disputes can also be dealt. However, under the Constitution, states are obliged to follow the act made by Parliament. If they will not follow, then under Article 365, President rule can be imposed. Hence, it is more like showing dissent of the state against the center. Fine. So now let us see what could have been the approach. Fine, that answer is reasonably good. What is citizenship? I have explained. Indian citizenship laws. You have to write the unique features of the Indian citizenship laws. Unique features are: Constitution provided for citizenship only in immediate context. Fine. And the Constitution leave it on Parliament to come up with more permanent and enduring laws. Article 11. Then the provisions of the Constitution have been dictated by the unique circumstances that have been prevailing. Subsequently, Parliament has brought Citizenship Act in 2003, bring necessary fact. Now Citizenship Amendment Act, you can bring OCI issue, etc. But this is the main theme why question was asked. Exemption, 6th schedule, period of naturalization has been reduced from 11 years to 5 years rather than 7 years. Thus, legislation applies to those who were forced or compelled to seek shelter. Now, rationale given by the government for bringing. It is a historical fact that the trans-border migration of population has been happening continuously between the territories of India and the areas presently in Pakistan, Afghanistan and Bangladesh. Millions of citizens of undivided India belonging to various faiths were staying in the said areas of Pakistan and Bangladesh when India was partitioned. The constitutions of Pakistan, Afghanistan and Bangladesh provide for a specific state religion. This is taken from the bill itself. As a result, many persons belonging to Hindu, Sikh, Buddha, Jain, Parsi and Christian communities have faced persecution on the ground of religion. Some of them also have fears about such persecution in their day-to-day life, where right to practice, profess and propagate religion has been obstructed. Many such persons have fled to India to seek the shelter and continue to stay in India even if their travel documents have been expired. However, the bill has been opposed not only by the opposition parties but also by the civil society. There were widespread protests against the country, like much publicized Shaheen Bagh protest. And I think in that answer, one good point was, it was seen in connection with citizenship laws, have been seen in connection with NRC, where it has been feared The Muslims have been feared that they will be denied the citizenship, and the Hindus, even if they are not citizen, will get the citizenship status. So this point is missing in this answer. My answer you can add, that is a very valid point. Primary ground on which citizenship amendment is being challenged, it is violation of the right to equality. The petitions before Supreme Court urge that not only religion-based discrimination are arbitrary, unreasonable, but that amendment is also under-inclusive. It cherry-picks only certain communities and ignores the persecution faced by millions. However, the arguments of the government are no constitutional court can question intention and motive of the government in enacting any legislation. The constitutionality of any lawfully enacted legislation has to be first presumed by constitutional court. Means court has to presume that the law is valid. Mere possibility that the law can be abused doesn't make it unconstitutional. Next, any classification cannot be scientifically pure. It is also supported on the ground that the origin of CAA can be traced back to Nehru-Liaquat Pact, whereby both India and Pakistan agreed to protect the minority rights. However, in light of the incessant persecution that minorities face in the three neighboring countries, it befalls the Indian state to ensure that obligation of 1950 Pact are carried out. Center said, after considering the totality of factors of international geopolitics, demographic profile of the nation surrounding the particular neighboring countries, the situation or presence of other persons of classified communities in other nations surrounding the neighboring areas, make it amply clear that India represents the sole rational and logically feasible place to seek shelter for the said community. The center in the affidavit said it is submitted that constitutional morality is not an unruly horse and cannot become an independent basis for challenging the constitutional validity of enacted legislation. It is to be noted that even USA has Lautenberg Amendment, which allows special treatment to the Jews and Christian communities. The state of Kerala has challenged the constitutional validity. Whether it can challenge or not, these are three cases. State of Karnataka, because 131 was also in news. Either a separate question can come or a combined question can come. Held that state need not to show that its legal rights are violated. In 2002 MP case, they said no, if root of 32 and 226, 131 cannot be taken, because if it is against Article 14, you should go under Article 13. In 2014, state of Jharkhand held that it is not understood why question examining the validity cannot be challenged. So the matter is referred to a larger bench. So now let us do the fourth question. The question is the doctrine of cooperative federalism. So for that I have picked the answer copy of another student. So the doctrine of cooperative federalism requires union and state to work in harmony towards achieving larger goals of good governance. Comment on the basis of some recent developments that good governance will require working together. Explain the problems and the potentials of Indian federalism. Fine. So what is expected in this question? The doctrine of cooperative federalism requires union and state to work together in harmony. So what is expected? It is expected that a student should explain federalism, and here a student should explain that federalism is an arrangement for a diverse societies where units seek unity without uniformity. And then it is expected that a student should know what is cooperative federalism. So he or she should write there are different types of federalism, and India, Canada, they are examples of cooperative federalism. And then a student is expected to write what are the features of cooperative federalism. To be able to explain cooperative federalism, you should compare it with American model. So American model is a dual federation which is based on independence. Cooperative federalism is based on interdependence. So in India, how India is a cooperative federalism? So we have finance commission, union can issue directions to the state government, bills of the state can be reserved for president's consideration. Cooperative federalism के institutions like interstate council, zonal councils, these things also you can mention. So when cooperative federalism can be successful, because these two forms of government, they are not independent, rather they are interdependent, so they will have to work in harmony. Now the question is on the basis of some recent developments. The recent development is like the COVID crisis. The recent development is like GST issue. The recent development is like farm bill, the labor laws. So India also has that concurrent jurisdiction or concurrent list. So if you know, or if India has to better integrated with international economy, like GST reforms are necessary, but GST type of reforms are not possible without cooperative federalism. So cooperative federalism has to be essentially consultative federalism. This is the point Supreme Court has mentioned in Delhi versus LG case and other cases also. So this is how you should be handling. Now what are the problems and the potential? So potential is very huge because there has been a rationale why we adopted cooperative federalism, because there is a poverty, there is a regional imbalance. In a cooperative federalism, center has a dominant role, India facing insurgencies, secessionist trends. So potential is very high. If we work, center and state work together with the spirit of Team India. However, the problem will emerge if they cannot act in sync, if we do not utilize the consultative mechanism. And is there any fundamental problem in India's cooperative federalism? The answer is no. This answer no is not based on my opinion. It is based on the opinion of the expert commissions like Punchi Commission, like Sarkaria Commission. All these commissions said that no fundamental change is required. You should bring center-state relations here. Only they have suggested that we need to change the manner of working because the real problem is political and not the constitutional. Fine. So now let us evaluate the answer of this student. Now, avoid this mistake. It gives such a wrong impression that you cut in the very beginning. ठीक है? Overwriting, cutting. आप सोच के लिखो ना, एकदम से लिखने का क्या मतलब है? As an administrator, you should be planning things, ना? तो ऐसा यूनाइटेड वी स्टैंड, और अगर लिख दिया है कोई बहुत गलत नहीं तो लिखा रहने दो, वो फिर भी सही है. काटना या तो पहले सोच के लिखना है. कोऑपरेशन अमंग स्टेट्स इज द बेसिक प्रिंसिपल ऑफ कोऑपरेटिव फेडरलिज्म. नाउ दिस इटसेल्फ डेफिनेशन हमेशा जनरल से पर्टिकुलर के लिए आना चाहिए. पहले फेडरलिज्म एक्सप्लेन करो, उसके टाइप्स एक्सप्लेन करो, उस टाइप में यू एक्सप्लेन कोऑपरेटिव फेडरलिज्म. देन द डेफिनेशन इज रॉन्ग. cooperation among states. What about cooperation between center and state? Is the basic principle of cooperative federalism. The government of India has rightly understood the importance of cooperation with the state for planning and governance. Is the government of India did this or the Constituent Assembly did this? Please be careful and in what you are writing. Formation, suddenly from Government of India, Constituent Assembly you jumped. Formation of Niti Aayog is a step towards. What about the constitutional provisions like Finance Commission? What about the constitutional provisions like Interstate Council? Focus has historically seen on central planning and states executing the plan, but Niti Aayog provides the platform for bottom-up approach. Now, who is asking the question on centralized planning? You are shifting away from the main question and it is appearing as if you are writing a question on Niti Aayog. Another classic example of cooperative federalism is the implementation of GST. Good governance without coordination among the states and the union is hard to achieve. But why? You have not written, you have written the question again. Fine, you should have written now why it is hard. There is no flow, factually wrong, not control on what you are writing. You are not planning and you are simply writing. A healthy competition among the states and cooperation among means you have forgotten the question. You are confused whether the question is competitive, cooperative federalism. What is the question? In federal structure of Indian constitution is very different from other. There is no flow, no organization, no systematic thinking. The problem with Indian federalism is that it is not pata nahi kya likha hai, conventional type and very asymmetrical. Thus there are a lot of complexity and the governmental rule may not apply and at times may seem it's all vague and very, very absurd answer. Fine. So now the doctrine of cooperative federalism requires union and state to work in harmony towards achieving the larger goals of good governance. So first of all, you should tell about good governance. Be ready with the quote because somewhere this question will come. So according to Arthashastra, the goal of governance is Yog-Shem, welfare of the people, and the welfare cannot be achieved good governance. So first of all, why good governance? Then what good governance? I have given this definition. You can give any definition of good governance. The best is whenever the question comes on governance, try to quote from Arthashastra. As per Arthashastra, good governance require collaboration among different institutions of the state. The students of political science or public administration must be knowing about the Saptanga concept. Indian federalism has always been controversial because of its centralized nature. Austin, the recognized authority on Indian constitution, has rightly explained Indian model as cooperative federalism. Then what is cooperative federalism? So adopt a comparative approach. How will you tell cooperative federalism if you will not tell what is a dual federalism? Then recent issues which have created tensions: demonetization, CAA, unilateral lockdown, conditional increase in the borrowing limit for state, PM Care Fund, GST, Farm Bill. At times the extremely centralized model, so-called quasi-federal model, is criticized. Both Sarkaria Commission and Punchi Commission, whenever question on center-state relations come, see whether you can fit in all these two. There is no need to alter the basic design. It is said that in India there is no center and state dispute. It is a party-to-party dispute. Hence, solution lies in the manner of functioning. India's cooperative federalism offer great opportunity for two levels of government to work, because they are asking potential. Half of the students forget the question itself. Subject to the condition, consultative, collaborative approach is to be adopted. Platforms like interstate council, एक way forward solution देना पड़ेगा, ठीक है. Granville Austin said strong center does not necessarily mean weak state. Polity के question में try to substantiate with the judgment of Supreme Court. Supreme Court in this case emphasized on collaborative and cooperative federal structure. Let us discuss question number 5. Even after 28 years of 73rd and 74th Amendment Act, local governments do not have the promised transfer of funds. Critically examine. ठीक है. So first of all, there will always be a possibility of a question on Panchayati Raj. So even after 28 years of 73rd and 74th Amendment Act, the local governments do not have the promised transfer of funds. So the answer should be, first of all, write the importance of local government. So if you go by the principle of good governance, and as mentioned in second ARC, the local government is the third tier, but it does not mean that it is least important. It is most important, because the theory of good governance says closer is the government, more accountable and transparent it will be. So even second ARC emphasizes on citizen-centric governance as a key to good governance, and in this citizen-centric governance, the institutional structures or status institutional structures like Panchayati Raj and municipality play a very important role. Now the question is on the transfer of the funds. So you have to write the importance of the transfer of the funds. For any government to function effectively, it should have clear functions or powers, funds, functions and functionaries. The wheel of the government cannot move without the funds. Now, one of the reasons for the failure of panchayats earlier was the lack of adequate funds. Hence, in 73rd and 74th Amendment Act, we have there is a provision for the State Finance Commission, so that local self-government gets a regular and a dependable funds. Now, besides this, these amendments also give an additional duty to the Finance Commission to give recommendations to the Union government about how to enhance the funds and how to meet the funding requirements of the third level of government. Unfortunately, it is seen as that 73rd Amendment Act has been a half-hearted measure and the real will has been always missing. So the situation before and situation after is not very different. The Economic Survey of 2018 has mentioned the low equilibrium trap, by which it has pointed out that in comparison to other countries, the status of panchayats or local self-government is bad. They are primarily dependent on the devolved funds, and they are not having enough, or you can say they do not have their own funds, rather they are dependent on the devolved funds. The situation of municipalities is better, but situation of panchayats is very bad. In certain states like Bihar and UP, they are almost dependent on the devolved funds. The having its own revenue is very, very important, so that these government can take independent and timely decision according to the needs and requirements of the people at the local level. Again, you can also mention that not only enough funds are not available, center is still continuing with its centrally sponsored schemes, and not only this, that adequate funds are not available, certain fiscal reforms like GST has further undermined the position of panchayats, because though states are represented in GST council, the panchayats have not been represented, so they do not have say with respect to the GST, which submerged certain taxes which have been very, very important from the perspective of panchayats like octroi. Hence, a way forward is that you have to give them sufficient funds, otherwise they will not be able to fulfill the constitutional mandate. And good governance is not only a developmental issue anymore, it is a strategic issue. Considering the growth of left-wing extremism, etc., we have to address not only the developmental deficit but also the democratic deficit of India. Fine. So now let us evaluate the answer of a question, answer of a student. The 73rd and 74th Amendment Act inserted a new schedule in the Constitution regarding Panchayati Raj. Why the new schedule only? New features in Part 9. The municipalities, so this is technically wrong in the introduction, which itself will create a bad impression. These both amendments provide us the way to grassroots democracy. Gandhi ji had always envisioned, preferably right Gandhi ji is not good to hear, had always envisioned the down up approach. ये डाउन अप अप्रोच कौन सी है? बॉटम अप अप्रोच तो सुना है. He always mentioned to strengthen the roots first. Both the panchayats and municipalities are dependent on state government for various needs, the most important being the transfer of funds. The problem with the funds has been from starting. The major sources of revenue for local government has been the property tax. Fine. वाह, ये आंसर यहाँ कैसे खत्म हो गया? और इस आंसर में तो कुछ था ही नहीं. मतलब you need to do hard work. Fine. So let us see the answer which I have prepared. So even after 28 years they do not have promised funds. So what you have to write about 73rd and 74th Amendment Act, and especially which provision it makes. Establishment of State Finance Commission, a counterpart of finance commissions, and the creation of district planning committees. And except from some success stories like Kerala, there is a systemic failure. Reluctance of state from, there has been no perceptible hand holding and support by the state governments. There has been no institutional decentralization, bypassing the constitutional institutions funds. Now the question is, increasing allocation to MPs which started and their state level counterparts has further resulted into diversion of the funds which could have been given to the panchayats. Following amendment, Finance Commission was amended and designed to empower the panchayats. And then Finance Commissions have given recommendations in favor of devolution of funds. But the term of reference of 15th Finance Commission is not that encouraging. And this is the study that even after 28 years, local government expenditure as a percentage of total public sector expenditure is just 7% compared to 24%. So allocation of fund is so poor. Functioning of state finance commission is not satisfactory. The state governments have not laid down the reports also. GST reform have undermined the financial power. Property tax collection with appropriate exemption should be compulsory. Levy and preferably must cover land. Economic survey talks about low equilibrium trap. In states like UP, Bihar and Jharkhand, local tax collection is next to nil. Way forward. A recent study by Professor Mathur says that the share of property tax in GDP has been declining. So all states have to go ahead with that. This problem was even mentioned in economic survey. Refer the government document. Suspension of MP LATs for 2 years is a welcome measure, but this fund should be assigned to local government. Then 15th Finance Commission should increase the allocation. We should not ignore, you should also write some concept. We should not ignore that the success of democracy at the top has to be built from the bottom. The local self-government are increasingly going beyond the traditional civic functions. They have emerged as the front warriors. Modi has acknowledged the vital role of panchayats that play in development and democracy while launching schemes like E-Gram Swaraj Portal, Swamitva scheme, and strongly urged each panchayat should be made self-sufficient enough to fulfill its basic needs. Now the next question: in a parliamentary system, government derives its legitimacy from the confidence it has in parliament. In context of the above statement, critically analyze the significance of the question hour. Okay, so what is expected here? You should explain what is a parliamentary system. So in parliamentary system, the center of the gravity of the government is in the parliament. Government is accountable to parliament. Fine. And can remain in power so long it enjoys the confidence of the house. So executive is accountable to parliament and parliamentarians are accountable to the people. So this is how the government draws the legitimacy. In context of above statement, critically analyze the significance of question hour. So you can always say that in parliamentary system, the role of opposition is as important as that of the role of the government, because opposition has to hold the government accountable. You have to go into the conceptual part here. That is why in Britain, opposition is also known as Her Majesty's opposition, as well as along with that in Britain you have Her Majesty's government. Opposition in India, the leader of opposition in India has recognized statutory status. His status is at par with the Minister of Cabinet rank, and opposition in India has different tools to hold government accountable, like you have question hour, you have power to bring motions. So question hour has been a very important tool, and it's not only for government to hold accountable, but it also to create awareness among the people about what is. It is also an indirect way of people's participation. It also helps government also to gauge the barometer, to understand what are the expectations. Though this is not the first time that it has been suspended, there have been things, there have been occasions in the past. Now, considering the very abnormal type of a time that is going on, it is understandable that government has suspended it, and however, it is to be noted that the members can still get the written reply. Though this has happened, but it is essential that it should not become a regular feature like that of an ordinance Raj. Fine. So this is what I have discussed here. We choose the parliamentary democracy in keeping with our old tradition, adjusted to new conditions and new surroundings. Nehru. The edifice of democracy demands eternal vigilance. The modern way of life necessitates a representative government. Fine. And then out of the three branches, parliament has supreme position. Opposition is an integral part. That is why you use the term Her Majesty's opposition. The basic purpose of question hour is to seek the information, elicit facts on matters of public importance without which they cannot fulfill their responsibility. It also helps the government to know the grievances and expectations of the people. Thus, apart from acting as a check on executive, parliamentary questions are aid to the executive. The importance of question hour in India can be understood by certain instances where they have led to the setting up of inquiry committees also. Then you give some factual aspects. The first hour of every parliamentary sitting is a question hour. You have three type of questions. In the midst, government's decision. However, government's argument is disruption. Government says anyway question hour is hardly productive, not a constitutional compulsion. It is a part of the rules of procedure or business. Accountability framework remains. MPs can still get the written answers, not suspended for the first time. But you cannot go very much against the government, but you cannot appear bhakt also. So what you can write, though it is understandable that the present decision is influenced by the extraordinary circumstances, suspension should not become the new normal and a colorable exercise of power. So you should also show your point of view. So now let us see how is this answer. In a parliamentary system, government derives its legitimacy from the confidence it has in the parliament. Article 75 says that Council of Ministers shall be collectively responsible to the House of People. Okay, it's a good start. This enforces executive accountability, and majority in the lower house ensure political legitimacy to the government. Political legitimacy to the government, I think sentence could have been framed better. You could have written that government is accountable to parliament and parliamentarians accountable to the people. So indirectly government is accountable to the people, and that is the basis of its legitimacy. Significance of the legitimacy, it helps to bring the major reform in the government. Okay, fine, helps, but please I think you can frame better answers, but you have a good approach. Helps government to build political consensus as mood of the nation favors them. Don't use these type of casual words, mood of the nation and it's cool, these type of things. Fine. So I don't think it's a very formal way of expression. It brings political stability which will reflect in the economic stability. Foreign powers can freely discuss the contentious issues with the government. What is the use of this? Foreign powers can discuss with foreign countries. Government can discuss the issue. I think this statement is carelessly framed. Government can free from policy paralysis. I don't know why you have written so much on the legitimacy. A very brief view of legitimacy was better. In context, analyze the significance of question hour. It enforces executive accountability, but you have not told now what is a question hour, why question hour. You should have written something on the role of opposition. It enforces executive accountability. Through the question hour, government is able to feel the pulse. Fine. It helps minister to gauge the popular reaction. That is also fine. It brings hidden things into notice. Sometimes question may lead to appointment of the commissions. Fine. But there are some concerns. Often it is used for scoring political point. It leads to unnecessary criticism. Sometimes political arrogance can cause disruption. Question hour is the first hour of the house, which is to check the executive and also allow. So I think if you will properly systematize, if you give more thinking before you write, you can write a better answer. And just for the sake of writing, don't unnecessary extend. Like for me, legitimacy part is unnecessary extended. Fine. So now let us see the next question. The next question is an important issue, and that is, it's not clearly visible, the copy which I have. What is the law regarding the contempt of court in India? Justify the rationale behind the provision. What are the guidelines given by Supreme Court in case of exercise of power of contempt of court? So ideally you should start this. What is a contempt of court? Fine. So what you can say that the origin of contempt of court can be traced to common law tradition. Fine. And in India, this provision has been traced to the British tradition. And then you should have explained the rationale. Fine. So for existence of a society, it is very important that people obey the law and follow the order of judiciary. Not just the common man, even government has to obey the orders of the judiciary. For example, if the fundamental right of a citizen is violated and Supreme Court gives any order, but the executive ignores it, so that will result into a big constitutional crisis. So more than the common man, it is very, very important that the government should obey the law. Now, in any political system, the stability, peace and order to large extent will depend upon efficient functioning of the government as well as the respect judiciary enjoys. Fine. So as that is why the courts, especially the higher courts, they are given power to punish for its contempt. Now the question is asking, what is a contempt law? So as per the Constitution, Supreme Court and High Court are the courts of record, and courts of record enjoy the power to punish for its contempt. There is also a case by which Supreme Court held that Supreme Court can exercise this power on behalf of high courts and subordinate courts so that the confidence of the people remains in judicial system. Now, the Constitution, this contempt of court provision, it is mentioned in the concurrent list, and Parliament can bring the laws for application of the contempt of court. So for regularized application, because contempt of court can also be seen as one of the reasonable restrictions mentioned on freedom of speech and expression. Accordingly, Parliament has brought the Contempt of Court Act 1971, which was amended I think in 2006, and it defines what is a civil contempt and what is a criminal contempt. if somebody disobey the order, doesn't implement the order, then it is a civil contempt. But if you do anything that lowers down the prestige or the confidence of the people in judiciary, it is seen as criminal contempt. For example, you write something which is not decent enough for or against a particular judge, it can be seen as a contempt. So though Parliament has made a provision, yet it is a constitutional power of a Supreme Court, it's the original power of Supreme Court. Parliament law does not restrict the Supreme Court and High Court's power to punish for its contempt. Anyway, contempt of court says that if for in case of a criminal contempt, there can be an imprisonment and fine. However, to establish a harmony between the contempt of court and freedom of speech and expression, an amendment was done which says that if something is written which is truth and for the bona fide purpose, then you can be protected. And normally nobody is punished for contempt of the court. Normally the government there is a provision to seek the apology and the courts warn and let it go. However, in recent time, it is being felt that the judiciary has exercised its power in a way which restricts the freedom of speech and expression, which is the oxygen of the democracy. So certain controversial exercises of power which have incited the controversy is the recent case of Prashant Bhushan, earlier against Arundhati Roy, against Delhi University Professor Sai Baba, or against Medha Patkar. So sometimes when the court uses the contempt of court power in a way which does not appear justified to the people, it is often cited as that judiciary is acting with high-headedness. Fine. So it is very essential that the contempt of court power should be used in a way that does not invite the criticism. See, this relationship is very, very fragile. It is very important for democracy that people have freedom to speak. In the Western countries, they have regularized the contempt of court power. Now, until and unless it is very, very serious offense, nobody is normally punished. Again, Lord Atkin's famous statement you can mention that justice is not a clustered virtue, it should be open to scrutiny. But while it is important that the court give respect to the freedom of speech and expression, it is also important that the same democracy cannot survive if people lose the confidence in the judiciary, and hence especially the public intellectuals, they should refrain from the unnecessary criticism against the judges. So this is a very fragile type of a relation, and it has to be acted in both. It has to be exercised in accordance to the constitution and in the best interest of the people. Fine. So now let us see how the person has written this answer. The recent controversy regarding the contempt of court proceedings against the human rights activist and the senior lawyer Prashant Kishore. So there is no need to qualify human rights activist and a senior lawyer. You can simply write senior lawyer, have again surfaced the debate. The Supreme Court of India along with High Court has been designated as a court on record by the Constitution. Good. This provision gives the highest court the power to punish for its contempt. The contempt could be of two types, civil and criminal. Perfect. These powers have been given by the Constitution. Supreme Court itself has said in the past that the power of contempt is not for judges to use arbitrarily, rather in the aid of delivery of justice. Very good answer. In the recent case, including Prashant Bhushan, many retired Supreme Court judges, lawyers and people at large have heavily criticized Supreme Court. Don't use such a such adverbs and adjectives. Fine, you should write in a more neutral way. As in the famous case of London tabloid Daily Mail on contempt of court, judges have said judiciary must have broad shoulder. It is therefore expected by the judges to adhere to the spirit behind the contempt of court. This is a probable question, so I have prepared a very comprehensive answer. You can have a look on it. Now, this student has otherwise written fine, but this part of the question is not addressed, that is the guidelines given by Supreme Court. Even while I was discussing, I forgot. So the guideline given by Supreme Court is in Mulgaonkar case. You should also remember those guidelines. Let us match this answer with our answer. For me, it's a sort, I can say it's an average answer, not that great. So it's one, since it is an expected question, I have taken a lot of pain to prepare the answer. So please go through it properly. So Alexander Hamilton's statement that courts are the weakest of the three branches of government because they neither have, see, this can come in your essay also, control the sword nor the purse. Hence they have to be given power to ensure the compliance with their judgments. And recently Supreme Court power to punish for Prashant Bhushan for the tweets. Supreme Court has commented. Fine. So it's important that you should know about Supreme Court's view, if not word by word. Fair criticism is welcome. Judges cannot be hypersensitive even when distortions and criticism overstep the limit. However, same cannot be stretched to permit to make malicious and scandalous statement. Court has to act only in the case where attack is beyond a permissible limit. The strong arm of the law strikes a blow on him who challenges the supremacy of the rule of law by fouling its source and stream. Okay. Now, historical underpinnings, I think this answer can be very useful even if it comes for essay. Going back to the 3rd century, contempt finds mention in Kautilya's Arthashastra. He lays down that contempt of Sabha Samiti and insult of the king shall be punishable, sometimes even by cutting the tongue of the accused. The burden to maintain the sanctity and majesty was not only on commoners but also on those who administer justice. Under the colonial rule, various common laws gave powers to the judges to punish for their contempt until the Contempt of Court Act 1926 was enacted to codify and define. This law was enacted on the line of recommendation of Tej Bahadur Sapru. Present Indian law has its roots in the colonial law. The status of contempt laws in free India. Fine. So in 1950, under Article 129 and 215, Supreme Court and High Courts have a power, and on the basis of Sanyal Committee, this 1971 law has been passed. So you must be knowing civil contempt and the criminal contempt. Then the punishment 2,000 rupees or imprisonment up to 6 months. Accused may be discharged or the punishment awarded may be remitted if an apology is tendered. Rationale behind the provision, I have already told you. This is important, that this is not to protect the judiciary, it is to protect the common man. The rationale behind is to safeguard the interest of the common man who would be adversely affected if court's authority is undermined and public confidence in judiciary is eroded. The power of contempt is not meant to protect the judges from criticism, where every individual and institution performing public function can be subjected to public scrutiny. Fine. So the basic rationale is in the interest of the common man, because the faith in judicial system should be retained. The case of Prashant Bhushan is not the first case that has created controversy. So Arundhati Roy case, Madhu Trehan's case, Medha Patkar's case, criticism. It has been criticized that it restricts the freedom of speech and expression. Law provides sweeping discretionary power on specific action. Two judges might have a different view. As per section 9 of the contempt, the scope of what is to be treated as contempt cannot be expanded, but actually there is no limitation. Why I am giving this detail? Because the question is asking the law on the contempt. Supreme Court deferred the hearing in another case against Prashant Bhushan, Tehelka wala, as in this case involved the larger question of law. Prashant Bhushan argued that the case involved the question of interpretation of the constitution and must be referred to the larger bench. His lawyer has submitted the list of 10 questions. The most crucial of the question is whether expressing the bona fide opinion about the extent of corruption in any section of judiciary would amount to contempt of court. Fine. So they can even ask question on the relationship between freedom of speech and expression and contempt of court. And then the Mulgaonkar principle, and Department of Justice sought Law Commission's opinion whether amendment is required. The Law Commission headed by B.S. Chauhan observed amendment was not needed. So I have also given the recommendation of Law Commission and then the global trend that criminal contempt is either not in use or it is used only when there is a substantial issue. And Lord Atkin's statement is very important: justice is not a clustered virtue. Now let us see what are the distinctive features of Indian secularism, because every year either in first paper or on paper 2 they keep on asking the question on secularism. So what are the distinctive features of Indian secularism? Why Indian model is called as contextual model? Do you think that the Western secular states need to learn from Indian variant? Okay, an interesting and a question that has been repeated number of times. So, distinctive features, contextual model, and why Indian model is called as contextual model. Fine, because repeatedly they are asking this question. So the three part is distinctive features of Indian secularism. Next, why it is called as contextual model and what Europe has to learn. So first of all, what is the general model? The general model of secularism is the separation between state and religion. This is the European model of secularism, because in Europe in medieval age everything was under the church, and then the church and state were separated and a state was declared as sovereign. Now what is the distinctive feature of Indian secularism? The distinctive feature is that there is no separation, rather a state can intervene in religion. Fine. For example, if we see Article 25 clause 2, a state can intervene in the Hindu religious customs for the purpose of reforms. Fine. Now, why Indian model is a contextual model? Why do we have a model where a state is not separated, rather a state intervenes in the reform? Because the model or the context in which the European secularism developed and the context in which our secularism developed has been very different. In Europe, internal reform movements had happened. Civil society was rational. That is why at times secularism is called as the child of Christianity and the fruit of modernity. So people had become secular, internal reforms movements have happened in the West. Fine. But in India, you cannot expect, because society is not that educated, society is not that modernized, so only state can bring reforms, and India has the traditions like untouchability which require a state's intervention, so separation is not there. Now the other thing is that in India minorities have been given a special rights. So sometimes people believe that secularism means equal set of rights, but at present the concept of equality has become very substantive, and always equality does not mean we ignore the differences. So Indian model is contextual again because it emerged in context of partition and the fear of minorities. That is why we have given special rights to minorities with respect to preservation of their customs and traditions. So it is actually framed looking into India's own contextual model. Now what West can learn? The West can learn because the Western model is based on equal citizenship, things like uniform civil code. But in Western countries, because of globalization, migration, refugee movement, these societies are also becoming very heterogeneous. So these societies should also give recognition to the multicultural approach to citizenship which is found in Indian Constitution, where we have given special rights to minorities. So two basic problems against Indian model of secularism is special rights to minorities. We do not have uniform civil code and there is no strict separation, but each model is unique according to its circumstances. Fine. So now let us see the distinctive features of Indian secularism. See, contextual model, there is one political scholar, Rajiv Bhargav. So I have given the points from his work so that you can understand his idea more deeply, but you can write in the simpler language and the points which I have just discussed. Fine. So the idea of secular state is of Western origin. It represents a strict separation between church and state. Western secularism is dominated by ideals of liberty and equality. Because we have to discuss the distinctive features, we should write about Western model. It is suitable for homogeneous societies. India is highly diverse society, so our model is Sarva Dharma Sambhav and these constitutional provisions. Though the word secularism was added by 42nd Amendment Act, but fundamental rights and universal adult franchise already included this idea. Then you should always give Supreme Court's definition. There are two important cases. St. Xavier's case, which held that Indian secularism is neither anti-God nor pro-God. Aruna Roy case, where we have been told that Indian model is a positive secularism model. Positive secularism means we do not see religion as a negative force, and there is no harm if religious teachings are taught in the schools. Though our constitution prohibits religious instructions, but it does not prohibit the teachings of the different religion, the great people and the prophet. Indian model is at once Indian as well as modern. Fine. These are like, I have given exact words, but you can simplify it. It's a practical concept than a coherent doctrine. It builds on India's own civilizational resources of Sarva Dharma Sambhav as well as the legacy of the British state. At the same time, it innovatively transforms both. The distinctive features of Indian model are: it rejects the strict separation. It deals simultaneously with interreligious and intra-religious domination. It has an explicit multi-value character. It implies neither respectful indifference nor active hostility. It is ethically sensitive, practical settlement, considering the minorities. Over last few decades, secular state has come under strain everywhere. With the growth of immigration, even Western societies have become heterogeneous. Religion is one of the toughest challenges faced by the states in search for peace, stability, harmony and cohesion. Paradigm of secularism is based on strict separation is in crisis, be it France, Germany, Sweden or USA. Banning of Islamic clothing, kosher or halal meat, backlash against immigrants show that Western model has to seek a middle ground combining religious neutrality and recognition of identities. In these countries, minorities are making special demands for accommodation, whereas majorities are feeling their historically privileged position is threatened. Rise of Islamophobia in US and Europe suggests any move to accommodate minority aspirations would face significant opposition. Instead of looking at what went wrong in their model, they should look towards countries like India, which managed large diversity working within a democratic framework. Western countries need to understand neutrality is insufficient where religion has become an important part of identity. West needs to come up with the solutions that go beyond secularism. They can learn from India's model of secularism, which exemplify the management of diversity within a democratic setup. Both India and West need to understand that anxieties about religion and lack of respect can be tapped by the vested interests to create rigid and close identity. Different communities have to be made stakeholders by ensuring their participation. Constitutional guarantees have to be supplemented with government policies ensuring equal security and respect. So now let us see how a student has dealt. I think this we have done. Let us see this answer. What is the distinctive feature? Secularization or secularism. First you all decide and then you write properly. Is a Western concept which is a gift of Christianity and resulted in the birth of modernity and was hitherto implicit in our preamble and later in 1976 was made explicit. Good. Distinctive features of Indian secularism. India is not a strict separation. Make a proper sentence. Indian model is not a strict separation. Rather, religion, rather a positive intervention in the matter based on idea of Sarva Dharma Sambhav, leading a political attitude. It's fine, idea is fine, but please frame your sentences properly. Indian secularism, best understood Nehruvian secularism. Why Nehruvian is best? No idea. Gandhian secularism, Ambedkar secularism. Why Indian model is contextual, Western model is procedural, or Lasite model where complete separation. But in India, through principled distance is maintained, yet India can interfere in the matter. Question is something else and you are writing something else. You are writing the features. You have to write why, what are the special historical context in which this model has come up. The idea of toleration is positive. India's multiculturalism value versus value pluralism of West. See, whosoever has written, he has written in a very exactly from the political science notes. Please don't repeat, keep it more general and adopt the approach that I have done. So now the next question is anti-defection law. Anti-defection law is also in news because of MP, because of crisis in Karnataka, because of crisis in Rajasthan. So I have put anti-defection law. To what extent 52nd Amendment Act has been able to tackle the evil of defection? Certainly not, because defections have become more rampant, suggests the needed reform in existing law. The most important thing is a speaker should not be made the whole sole authority. Certain changes should be introduced, like a speaker has to be given a time frame within which it has to decide and all, to make it more effective. Let us see the answer. Aya Ram Gaya Ram was a phrase that became popular in Indian politics in 67 for defection. The anti-defection law sought to prevent such political defection which may lead to political instability and horse trading. Fine. The law laid down various provisions under which members can be disqualified: voluntary resignation, votes against party whip, and independent member. Fine. Nominated members. But you need not to write these things in detail. You can write precisely little reference. Law provides exception in case of merger. Even after having a law, defections are regular sight. Recently in Madhya Pradesh, Karnataka, Goa, the defections are happening in lieu of ministerial work. This amount for fraud with the voters and impose an additional burden of another election. The role of a speaker who is not neutral makes the whole process skewed. Good analysis you have done in favor of the ruling party. After Kyoto Holohan case, very good, this case should have been mentioned. A speaker's decision is under the purview of judicial review, but more needs to be done in order to curtail unethical defections as recommended by Dinesh Goswami committee. Anti-defection law. So this is a good answer. It is giving facts, it is addressing the question, and it is also giving reference to the Dinesh Goswami committee law commission. So in that way it's a good enough question. Fine. So now let me show you what all information I have included. To what extent 52nd Amendment Act has been able to curb the problems of defections in India. So here I have given a judgment of Kyoto Holohan which tells about the problems, that provisions are salutary, intended to strengthen the fabric of parliamentary democracy by curbing unprincipled and unethical defections. ये जितने भी क्वेश्चंस हैं ये सारे probable question हैं. Introduction, conclusion तो याद ही कर लेना. The politics of defections has been the bane of parliamentary system, more rampant at the state level. Defection is an evil because it negates the electoral verdict. It causes political instability, horse trading, promote the use of money and muscle power. See, people change the side not because of the ideology but because of power or money. Principal defections are rare in India. Then there is a data how many defections have happened. Then Rajiv Gandhi government bought the bill. This act was amended by 91st Amendment Act. Now instead of writing very elaborately on the provisions, you can just write the flaws. It does not define voluntary resignation. It makes a speaker the ultimate authority. Original act prohibited individual defections. Act does not define the time period within which a speaker should take decision. Howsoever good a law is, if man doesn't want to obey it, they can always find the loopholes. The recent cases in Karnataka, MP, Manipur show 52nd Amendment Act has not been able to check the defection. At the same time, it has created new problem. It brought the institution of governor, speaker also in disrepute. It has a potential to disturb the federal feature. It has created situations where judiciary has to intervene in the domain of parliament against the constitutional mandate. So though judiciary has tried to address some of the loopholes, it is high time entire act should be reformed comprehensively in light of the recommendations. So these are the expert committee recommendations. So now the last question and the last copy I will for today. CAG referred as the auditor of the nation. Why this question? Because last time they asked Attorney General, now CAG is also in news. So one simple direct questions from the institutions is asked. CAG referred as an auditor to the nation in the financial watchdog that closely monitors all government revenues expenditure. Fine. So of the 5 C's, CAG as a body holds great significance in the proper functioning of the government. But how do I know what are these 5 C's? Fine. So either you tell what is 5 C's, and don't commit such mistake in the beginning. CAG as provided in article, you are not sure, one of the most important constitutional bodies. So you could have just mentioned about Ambedkar's view. It audits all the account. It has a vigil over extra expenses. It audits accounts of public sector enterprises. It helps. CAG not only accounts for revenue and expenditure, it also prescribes suggestion as to the efficient allocation, wise use of resources. Fine. As a whole, CAG is like a auditor of the nation, a watchdog, a financial monitor. Its significance can be ascertained as constituent status independent is this. Fine, but lot of scope for improvement. So let's quickly have a look on this. So normally remember some of the judgments to these simple answers to make it special. CAG is often cited as a cause for unwillingness in decision making. It's very important that CAG upholds the entire gamut of audit functions where public interest is involved. So it is saying about the scope of CAG function. Context of the institution is the accountability. Role of CAG in Indian political system, it is a supreme audit institution. And we have a parliamentary system. CAG's role is to assist the parliamentary account committee. Ambedkar held that CAG is the most important officer. Radhakrishnan held CAG is not responsible to the government, rather he serves the people. These are the articles 148 to 151. Either you know correctly, otherwise don't mention. Article 151 requires CAG reports to be submitted. CAG typically undertakes 3 types of audit. Independence of CAG is ensured by its system of reviewal. Over the year, CAG has played constructive role. CAG report indicated the Defence Minister V.K. Menon for contractual lapse. CAG report on Bofors, 2G Spectrum, Mumbai Adarsh Housing Society, Augusta Westland, VVI choppers. Some of the recent findings in CAG audit regarding the cess issue you must be aware of. Swachh Vidyalaya Abhiyan. You can read offset committees, strategic role of PSUs. However, CAG's record is not unblemished. There has been a controversy over redactive pricing. Redactive pricing related to Rafale fighter jets. There has been a controversy over appointment of a Murmuru as a appointment whose methodology is being criticized as non-transparent. Another weakness is that majority of CAG reports are not examined by Public Account Committee. CAG has reported lack of cooperation by ministries in submitting the report, absence of controller function. CAG basically does post-mortem. Government department do not reply to CAG inquiries in time. There is no clear time frame for tabling the report. CAG reports are used by Public Account Committee. However, data shows 1% of CAG reports are not taken up. To conclude, CAG has played a significant role as a fifth pillar. However, the institution must be reformed so that it can fulfill the constitutional obligations. So I hope this discussion has helped you, and go through these answers. I think they are also very good notes. For further doubts, you can always write a mail to us, and now you will also be having the classes on governance, and hope this completes your preparation for polity. Thank you.